Hello, Dr. Bechtel again. This is the third of a four-part lecture series on legal timekeeping and billing practice. This third one is on going to cover fee retainers. The objectives in this lecture define the types of retainers and what are the ethical implications of trust funds, client trust funds, and what is the Florida Bar Clients Security Fund. All right, so advanced fees are the monies paid by the client at the beginning of a case or a matter. And there are two types. One is an earned retainer. The other is an unearned retainer. An earned retainer is when funds are transferred to the attorney's operating account. An operating account is the account where they pay their bills from. Salaries, electricity, rent, whatever. An unearned retainer means that the funds are held in trust until the work is completed. And Florida Bar requires advance fees to be held in trust accounts until they're earned. All right? Attorneys must refund any unused portion of retainers or deposits, and non-refundable retainers are permitted only if clearly explained in the fee agreement. So the main idea of a retainer agreement or advance fees is to have some security for the fees that the attorney is going to charge. It's a predictive thing, and have that money available to them instead of, just a safe place, I guess. Should be. Although there have been, you'll learn at the end of this one, there are some times when it's not a safe place. Anyway, security retainers, let's look at the advance payment retainer. So the definition of the advance payment retainer is, well, first of all, it's the most common type. The client pays up front, and funds are held in the trust account. And each time the lawyer let's just put it the easy way, the billing system, the time entries get entered, the expenses get entered, and then the lawyer can take that bill, then it's earned, and then it's earned at that point, and for that bill, they can take the money from trust and put it into operating. And as I pointed out earlier, the purpose of the advance fees is to ensure there's a guaranteed funds for future services. The key point is that unused funds have to be refunded to the client. An availability fee is a general type of retainer, and it's a fee paid to have a lawyer available for a set period, maybe a month, maybe a year, and regardless of whether services are used. So it's like, I'm here for you, and to be here for you, I will have you pay me in a general retainer, and my availability will be here. And then they outline the types of issues that they handle in that general retainer. It's where there's some need for legal counsel at any time. Pick up the phone, call my lawyer. The key point of it is, unlike security retainers, this is an earned fee. So you get paid, it is earned, because that's the service we're going to give you. When you call, we will be here. A special retainer, like a flat fee retainer, is a fixed fee for handling a specific matter. So we talked about flat fees, drafting a will, handling an uncontested divorce, and so they will put that into a retainer. They'll pay that, and the purpose is, again, predictability for clients. It's a certain amount of money, and that's what it'll cost, and there's an efficiency on the firm's part for the routine legal services. One key point is they're often non-refundable once work begins. That'll depend on the jurisdiction. So some ethical principles about the retainer fees. And we've used these terms already. There are two types of attorney accounts, as in bank accounts. So at Bank A, they will have an operating account, and they'll have a trust account. The operating account is for depositing monies that ethically may be used for operating expenses like salaries, office overhead, etc. A trust account is where that money that is unearned gets deposited, and it's also used for, like, settle a case, and there's money is provided to the plaintiff's attorney that goes into the trust account. But but the trust account is used to deposit monies that may not be ethically used for operating expenses. And anytime the attorney applies the funds from the trust account to the client's bill, the client must be notified in writing of that. And they get that little letter usually. Well, back in my day, we had a letter that accompanied the bill, or a statement on the invoice that said that we've got this. Thank you. All right. Other ethical issues segregate the funds, and they must be kept separate. Each client has to have a separate personal trust account fund, and it has to be separate from the operating account. So you can't pay operating funds. You can't use trust funds for operations. Trust accounts are exclusively for client money, not for firm revenue or expenses. It's also a place for safekeeping property. I mentioned that earlier. Settlement funds, waiting to distribute an estate, and you're calling in and different marshaling assets and turning them into cash at times, and then that would be deposited into the trust account for safekeeping until it's time to do a disbursement to the beneficiaries. And they have to go in promptly. You can't sit on it. No commingling. You cannot mix client funds with the firm funds, like the operating account or the lawyer's salary. You don't commingle. You have to keep these accounts of operating and trust very separate. Even a temporary commingling and holding them in the operating account before transferring, that's even prohibited. Very serious rules around trust accounts. And accounting and record keeping, detailed records for trusts have to be maintained. So they are maintained on a ledger, whether it be electronic or a spreadsheet or a piece of paper in a book. We have to keep these records for often 5 to 7 years. And the office manager or accountant will be regularly reconciling the trust account. So it's typically monthly. Clients must be promptly notified when funds are received on their behalf. So if you get a settlement for a car wreck and you wait a month to tell the client, that's a little too long. Lawyers must deliver the funds or property to clients or third parties without delay. We talked already about earned versus unearned fees, so I won't distill too much on that. But of course, there are advance fees, which are unearned, and only after services are performed may funds be transferred to the operating. Cannot misuse the funds. May only be used for their intended purpose. Borrowing, delaying transfer, or unauthorized withdrawals is called misappropriation, and becomes grounds for discipline or disbarment. Client rights. They have the right to request an accounting of their funds at any time, and there have to be clear, accurate statements of trust account activity. So just like the invoice for the bill, the activity needs to be carefully explained and described. Lastly, for the rules, you can check the Florida Bar Rules of Professional Conduct, Rule 5-1.1, which emphasizes all client funds must be held in a separate account. Lawyers do monthly reconciliations. Non-refundable retainers need to be clearly explained in writing, and misuse of funds is considered presumptive disbarment, and misappropriation is one of the most serious ethical violations. Next, there are really tragic situations that go on where lawyers have taken money from clients. It was given in trust or was from the client, or a settlement proceeds. Look, you can Google this, and it's just sad what you see. I mean, people can just be taken down by a lawyer that keeps that money, uses that money. But the purpose, though, of the Florida Bar's Client Security Fund is protection to those people that go through that. It's created to reimburse clients who suffer financial loss because of that misconduct, like misappropriation, embezzlement. It's funded entirely by annual membership fees paid by the Florida Bar members. To be eligible, there must be an attorney-client relationship, and claims are considered only if the attorney has been suspended, disbarred, had their license revoked, or is deceased. The losses that get covered are advance fees and retainers. If fees were paid and no useful services were provided, reimbursement may be available. Misappropriated funds. If an attorney stole or misused client money, reimbursement may be considered. There are limits on the recovery. If it's about fees where no services were provided, up to $5,000 reimbursement. If it's a misappropriation claim where funds were stolen, up to $250,000 can be reimbursed. And claims are discretionary. The fund is not legally obligated to pay, even if the misconduct is proven. There are exclusions. It doesn't cover fee disputes or dissatisfaction with services. Negligence or malpractice does not cover. Business or investment losses involving attorneys does not cover. And damages beyond the actual amount misappropriated. So lost interest or consequential expenses that would be excluded from the reimbursement or the claim. The process is to file a claim with the Florida Bar. They have an Attorney Consumer Assistance Program called the ACAP. Claims are reviewed, and if approved, they're paid at the end of the fiscal year in June 30th. Payments depend on available funds, and if there aren't enough available funds, they'll prorate them. So, all 50 claims, they'll take, they'll prorate it based on the amount of their claim. So this concludes part 3.